Hey everybody, thanks for joining us for part two of estate planning. This is what we're calling estate planning nitty gritty. We're getting a little bit more into the weeds about this. If you're a little lost and you don't know why there's a part two, trust me, there's a part one. Please go find part one, click that link, watch it. That's a little bit more of a broader overview of what we've gone over. But to reintroduce ourselves, I'm Elian Levatino, financial advisor here at Benchmark Wealth Management, and along with me is Shannon Acosta. She is also a financial advisor here at Benchmark, and we're here to get a little bit more into the nitty gritty of estate planning. In our first episode, we talked about wills. We talked about estate planning in general and why you need a will, why you need powers of attorney, why you need trust documents if you need trust documents. This is where we're going to start talking about each one of those things individually and what are the essential parts of all of them. So I'm going to start with what are the essential parts of a will. When do I need one and how often should I update it? Decide what property to include in your will. In the last episode, we talked about assets, liabilities, debts, any of those things. All those things are part of your will. Selecting your beneficiaries, how your assets are going to be distributed, who gets what. If you're married and your spouse is still living when you pass away, you may just leave everything to them. You may have a blended family where you've decided to leave some to your new spouse, some to your old spouse, some to your children, some to your spouse's children. That's very, very important if you have a blended family so that you know what assets are going where. But also in your will, it's going to account for the possibility that you and your spouse could pass away together. The odds are very small, but it has happened and it is possible. So what happens if you pass away together? Who's going to get those assets? Who will get the children? How are the guardianship of the children if they're minors? How does that pass on to who's going to take care of them? And you can designate certain items for certain people too. If you have a grandfather clock or a collection that one child wants specifically, please be sure to name that inside your will also. You want to choose an executor for your will. Your executor, I've always classified an executor as, I have someone in my life who they really like to have all their shoes in a row inside their closet. Their socks have the days of the week on them, so they know, hey, I'm missing one of Tuesday's socks. Where did it go? They know exactly which sock is missing. Their clothes are always pressed. Hey, you get what I'm saying. This is a person who is maybe even a little bit OCD, someone who's going to read the will and make sure your wishes are carried out exactly how the will states. They're going to be the one that makes sure that the judge and the probate court understand what's going on and that they execute it not only to your liking, but to the court's liking also. You want this person to be very level-headed, ethical, responsible, someone who's not going to be intimidated by maybe some strong-willed family members who are going to disagree with what you've put in the will. They think that there could be some ambiguity and they want to fight over some things. Your executor needs to be able to set some boundaries and draw some lines in some places. So you definitely want an adult. An adult needs to be an executor, but it can be an adult child. It can be a parent, a family friend. You can even choose the attorney who wrote the document to be your executor. Normally, they're going to get paid for this, and that's fine, but they're going to get paid out of the estate. So make sure that part of the estate, there's enough money in there to pay for the executor. Each state has specific laws about how to handle compensation. So I don't know the specific state laws in Tennessee, but I think it uses the word reasonable. Take that for what it's worth. Sometimes it's a percentage of the entire estate, but be sure to talk to your attorney about the law in your specific state on how that would apply to you. And then some counties have some guidelines in place, and those are a little bit vague also, but be careful to look at all those for your specific situation. I alluded to this earlier. Please name guardians for your children. For some people, this is incredibly easy. Oh, I want my parents, or I want my spouse's parents, or I want my brother and sister-in-law, or whatever that is. Sometimes it's incredibly easy, but sometimes it is incredibly difficult. We've had clients, Shane, I don't know about you, but I've had plenty of clients who have balked at even starting the will because they can't answer this question. There's either no family, or there's not family that they trust, or there's not friends that they trust, and it will paralyze you and keep you from making these very, very important decisions. We know these are difficult. We know they can be hard, but they are oh so important for your, especially for your minor children. Be very, very careful, but don't let it paralyze you to keep you from making any of these decisions. And if you have the means, you can make provisions that compensate whoever the guardian is, whoever's going to take responsibility for your children. That can be a compensated role for taking care of your children for a very long time. That was a lot. If you need to pause, rewind that, watch it again. That was a ton of information of everything that goes into a will. Please have all those things ready to go before you go visit your attorney or before you start writing your will. It will save you a lot of time and a lot of billable hours from the attorney if you already have all those answers in place and ready to go. Shannon, how do you now you have all this, you go to see the attorney or you go to try to do it yourself. What are the next steps? How do you actually execute the will?
Thanks, Ellian. And before I go into the next phase of essential parts of the will, which is really enacting it, I have a confession to make. I was one of those people who could not figure out where we wanted the kids to go. And it took us 2 years after our oldest daughter was born to get a will in place. And I'm sitting here telling people every time I meet with them that they need to have one. Pot calling the kettle black. So I'm with you. I empathize. It is very difficult, but I can say that just getting it out there on paper is very, like, we started sleeping incredibly better after we did that. No lie. That's very sincere. And you can always go back and change it. Well, now that you have the will drafted and you have everything that you need in it, it needs to be signed in front of witnesses too. And none of the witnesses that are signing it can be inheriting anything from the will. They can't be beneficiaries. Technically, you don't have to have the will notarized, but it's just one of those things, like, it's easy enough. You should probably do it. It's going to make it easier for the judge to validate it. It's going to make things easier for your executor. So you can have your will notarized. There's really not a downside. We can do it in-house if you're at this step and you are hung up on that point. Let everybody know ahead of time what their role is in your will. We've all seen the movies where kids show up on somebody's doorstep because the parents passed away unexpectedly in a car crash, and now it's up to aunt and uncle to take care of them. Like, it's really cute and it makes for good comedy, but in reality, that would be a disaster. It's uncomfortable, and this is a very personal decision, and we're not going to tell you how to go about doing this, but we want to strongly encourage you to tell folks who have a role to play that they are indeed going to play that role. You really do need some of their buy-in in order for you to feel good about the decision that you've made. For example, you might name somebody as an executor, but they might be really busy. They might not feel as though they can do service to your wishes and execute their duties in a way that's going to live up to your standards because of the lifestyle that they have going on. And you'll want to know that ahead of time so that you can call an audible and find somebody else to fill that role. Sometimes clients read their wills to beneficiaries before they're gone. Again, this is incredibly personal. I don't have a strong opinion about this, Elian. I'm not sure if you do either, but there's pros and cons to doing this. If it's and if it's something you want to do, you're not alone, and it can relieve some tension and drama on the back end of things if it comes directly from the horse's mouth, so to speak. Now, a will is no good if nobody knows where to find it or even that it exists. Keep your will in a fireproof safe. Keep it someplace where somebody knows that it exists. If it's locked up, somebody needs to know where the key is or what the code is. We encourage clients to have a legacy drawer. And if you aren't sure what a legacy drawer is, then call us. We can hook you up with how to set one up. It's essentially a binder with gorgeous tabs, little pocket things where you can put things in the different sections, and it's clearly labeled, and it's pretty, and it's easy to maintain, and it's an OCD person's dream binder. If you put your will in here and you keep this in a fireproof safe, then everything will be in one easy to access, organized location. It's also good to have a digital copy and give a digital copy to everybody who has a role to play in the will, guardians, executors, etc. A will is the last gift that you're going to give to family and loved ones. So make sure that you are putting them first by having a will in place, period. Overarching theme of this whole entire financial foundations course. Elian, a will, the crux of everything, but we also talked about several other estate planning documents in the first episode. Can you go into a little bit more detail on what each of those entails and what our viewers might want to know in order to get those started?
Yeah, unfortunately, some people believe that after they get the will, they're done and there's nothing else to do. But there are some ancillary things that need to be addressed. Having healthcare decisions, if you're incapacitated, those are very, very difficult. But you want to make those decisions while you're of sound mind, rather than others wondering what would they have wanted me to do. I haven't had that pressure, but some of you have. You've had the pressure of, the doctor comes to you and says, "What do you want me to do? Here's my suggestion." You have to make the decision about a loved one. That is so incredibly difficult. To remove that responsibility from somebody else, to give them peace that you've made this decision for yourself, is incredibly helpful. So we're gonna suggest you look at a living will. And a living will, you can dictate. It's a very, very simple document. It can be one page, but that living will says, what to do if you can't breathe on your own. What should the doctors do? How many doctors need to agree? That type of thing. What if you can't feed yourself? How do you feel about feeding tubes? Do not resuscitate or do not intubate. How do you feel about donating organs? And if I'm not mistaken, I think you can even do that on the driver's license. At least you used to be able to, but you can dictate that in your living will also. And then, do you have any other special medical conditions that you want to be considered? All these things are incredibly important. Again, to remove that responsibility from somebody else, you're accepting that responsibility for yourself by putting it on paper while you're still of sound mind. Consider general powers of attorney. A power of attorney is where you give somebody the approval and the ability to sign documents on your behalf, settle lawsuits, make financial decisions, whether it be paying bills or accepting deposits or any of those things. Granting someone that authority on your behalf, even while you're of sound mind, and then sometimes when you're incapacitated. Most institutions are going to need a signed acceptance of a power of attorney before they'll allow that to go forward. So for example, you can't show up at a bank with a power of attorney document and expect anything to get done. That bank has to go through a validity process where they take that power of attorney, they go through all their internal processes to make sure that that is a valid document. So if you have a general power of attorney that you want banks and financial institutions to know about now, go ahead and go through that process, get all that done before the need actually arises. But a POA can also be springing, means it springs into effect at the time of incapacitation. So a durable power of attorney means they can have it while you're still of sound mind, in addition to after incapacitation. Springing only happens at the moment of incapacitation. So you want to have if you're going to give somebody a power of attorney while you're still of sound mind, you want them to be a maximum trust. This needs to be a spouse, a parent, an adult child, someone who is very, very close to you that you're going to have a lot of trust in. The springing means that it won't take effect until at the time of incapacitation. Usually there's multiple doctors that have made that declaration and they sign off on it and say, yes, this person is incapacitated, or you as the person is incapacitated, and that your power of attorney can now spring into effect. Usually your springing power of attorney is a spouse or someone incredibly close to you, again, in that situation, someone who you're going to have maximum trust in. There are ways to have special or specific limited powers of attorney. Means it will only jump into effect at certain parts of the estate planning process. And some of them can be very specific for the type of event, meaning, is it just financial? Is it just medical? Is it specific decision making? It can be very, very specific for all those things. And generally, a living will is going to trump a medical power of attorney. So putting a living will in place is going to override all those power of attorneys. But what's going to make things even better is if they all gel, if they all say the same thing. That way there's not going to be any confusion about what your wishes truly are. The last piece is you can consider a trust. Now, a lot of people jump into a trust and just assume that they need one, and that's not always necessarily true. They assume they need a living trust because they've been told horror stories about probate and how awful it is and how difficult it is to go through that entire process. Well, so that is true. It can be very difficult if you don't have your documents in order. If you have your documents in order, probate doesn't have to be that intimidating. But some people have chosen to do a living trust where you're basically creating an entity out of thin air. And you're saying, okay, I'm going to create this entity and I'm going to put as many assets in there as I can. A living trust can be revocable, meaning you can put assets in and then you can decide, you know what, I don't really want to do that. I want to take them out. There's no separate tax filing. You are the trustee. You have complete say-so in everything that goes on inside of there. There's generally not any tax consequences. It has some positives and negatives to it, but the biggest positive is that it can avoid probate if you've put all of your assets in some form or fashion inside of this trust. Not all assets are available to go into a trust, so you got to be very, very careful about that. You can have an irrevocable trust. You can revoke it, meaning you can put money in and out, but if you have an irrevocable trust, you've put whatever these assets are inside of this trust, and it's very, very difficult to get it out, if not impossible. It's much less inflexible. It does have a separate tax filing. So now this entity you've created, you have to file taxes for it. It can, the tax consequences associated with funding them can be a little cumbersome. It will lower your estate, your total estate for the purposes of estate tax management, but it comes with its own issues in and of itself. Lastly, there's something called a testamentary trust, meaning you haven't created trust while you're alive, but when you pass away, your will dictate inside of your will that says, at the point of my death, I want a trust set up for my estate, for my children, whatever you want it to set up. It will be done based on your wishes inside of your will. And that's something your executor, your trustee, and your attorney are going to do for you after you're gone. Look, trust can be very, very complicated, very costly, very time consuming. So this is not something to jump into kind of willy-nilly. When we say that this is the nitty gritty, we're really into the weeds of this. Trusts are very confusing, and they serve an amazing purpose. So be sure that you just don't jump into one, that you've really consulted an attorney. Come talk to us. We can help you decide if a trust is going to be good for you. We'll even talk to the attorney with you, but we find it incredibly important that you just don't jump into a trust because, as you can see from the previous explanations, some things can be undone and some things can't. So you want to be very, very careful. That was a lot. I said this in the last video. If you need to rewind that, stop, go back, look at all of it, decide if you need to stop there, dot some I's and cross some T's there. But let's jump into the next topic. Again, I said something about probate. Sometimes probate has a negative connotation to it. Some people are thrust into probate without really any direction from the person who's passed away. It can be very cumbersome. So Shannon, if somebody wanted to avoid probate, how would they do that?
Well, there are a few different ways, and you might consider them shortcuts to what the trust provides. And look, sometimes shortcuts are awesome. Sometimes they create more trouble than you could have avoided by doing it the long way. Our job is not to tell you which category you might fall in, but an attorney can help you with that. My feeling is that in many circumstances, some of these other methods can simplify the process for folks who don't need a complex trust in order to control their wishes beyond the grave. A few ways that you can do that. If you have a bank account or an investment account or a deed to real estate, you might consider a joint tenant with rights of survivorship. Or there's some other a little more nuanced methods to this as well. A joint tenancy could create a taxable event, so you want to be very careful. It could be tricky in the event of a divorce or a lawsuit. And there is an absolute lack of control for whoever the surviving party, usually a spouse, does once you pass away. But essentially, creating a joint tenancy means that I'm going to include you in the ownership of this asset. So if you have a bank account, for example, that's the simplest way to explain this, and you add your spouse as a joint tenant, then when you pass away, your spouse has rights of survivorship with everything in the bank, and they don't need a court to tell the bank that they have permission to utilize the money or the assets for their own behalf. Another method is using beneficiary designations, and these fall through several different smaller subcategories. When you have a life insurance policy, you're going to put a beneficiary designation, meaning that when the life insurance company has proof, death certificate that you've died, they're going to send the proceeds to whomever you've listed on your life insurance document, the one that you signed and dated. It goes directly to the beneficiary. It does not pass go, does not go through probate. Same thing with a 401k or a retirement asset like an IRA. You'll have the option, and oftentimes the requirement, to establish who you want those funds to go to in the event of your death. You can do the same thing with annuities. You can add what we call POD, or payable on death, designations to your bank accounts. In contrast to that joint tenancy that I mentioned earlier, a POD does not give anybody the right to utilize the assets while you're living. And backing up just a little bit, and that joint tenancy that we spoke of earlier, anybody you add to that can use the funds freely while you are still living. They own it just like you do. So it's obviously have to be somebody that you trust maximally. But with a POD, anybody whose name you designate there does not have any control or authority while you are still living. But they can take a death certificate and some other documentation to the bank to have things turned over upon your death. You can do the same thing with investment accounts or a deed for real estate. It's a slightly different nomenclature. It's called a TOD, or transfer on death. Don't know why they need to have two different terms for that, but they do. A third method to avoid probate is to have a small estate. If you have, in Mississippi and Tennessee, the amount is a little bit smaller than it is in Arkansas, but a small sized estate, small meaning like in the $50,000 to $100,000 range, give or take, then it's going to be expedited and a simplified process for distributing assets. And then finally, and probably least popular, is giving assets away while you're living. I mean, you have ultimate control of your money while you're living. So if you want Elian to get $10,000, rather than stating it in your will or having it go through probate, you can just give it to him now. Disclaimer. Wait, is that a joke that I should make?
Don't give me $10,000. Don't do that.
I don't know that I'm allowed to make that joke. So cancel, unwind. Anyway, point being, anything you give away while you're still living doesn't go before a judge because you've already given it away. Effectively, one married couple could give another married couple, you could take advantage of the annual tax exemption, like the gifting exemption, and you could quadruple that if you're one married couple giving away to another married couple. Talk with your CPA for more details on that. And it's of course going to depend on tax law changing, etc. Okay, let's just take a deep breath and rewind and refocus. Where have we been? Let's orient. We've covered the nitty-gritty of wills, the nitty-gritty of other estate planning documents we mentioned. We went through the nitty-gritty of how you can avoid probate. And remember, that's ideal because you can avoid probate court costs and it saves time and it's private. One other thing we want to launch into at this point is beneficiaries. How can you prepare, Elian, on this side of things for your kids to receive an inheritance, something that may in some cases be pretty sizable?
And I love that you hit on a couple of things that pass outside of probate. When you name beneficiaries and you've put the specific name on TOD, POD, IRAs, 401ks, life insurance, all that passes outside of probate, goes directly to that person. If you don't remember naming a beneficiary on any of those things, usually the default is your estate. And if your estate is named as primary beneficiary, it will go through probate and it will be subject to creditors, if you have any outstanding debts, all those types of things. So please be very, very sure that you have primary beneficiaries named on all of those things. You want all those things to pass outside of probate directly to those people to avoid that. Now, if you have,
can I jump in and say add one thing that I missed earlier? I'm so
Sure.
sorry to interrupt you. Has anybody ever been in a situation where you change your email address and then you forget all the different things that it's linked to, and you stop getting mail from people you want to get mail from because you forgot to tell them?
I'm picking up what you're putting down.
Sometimes trusts can simplify the matter, and because if you let me just cut straight to the chase. If you want to change your beneficiaries and you have a trust set up, you change it in one location. The trust dictates, and everything else that's in the trust is going to follow through those rules. If you want to change your beneficiaries, you need to ask yourself the question, where are these beneficiaries listed? Sneaky ones are retirement accounts at your work and life insurance policies that you took out 10 years ago. But those bank account PODs, the investment account TODs, all of those need to be changed on an individual basis if you have a change of heart, change of mind.
And as you can imagine, we see a lot of that kind of thing here. And one of the more difficult situations I've ever seen was a husband had left his 401k to the wife, but they got divorced, and he forgot to change his beneficiary and left it that way for 3 years. And when he passed away, it was not his intent because that money was actually split at their divorce as part of the marriage dissolution agreement. And it turns out she got the rest of it when his intent was that it go to his new wife after they had been remarried. It was a very, very difficult situation. There's a whole lot of complications that come with that. Please be very, very careful who you named as your beneficiaries. And anytime there's a major life event, that you're revisiting that. So going into let's jump into children, and if you decide to leave money to children, whether they're minors or adults, it can be very, very complicated. If they're minors, if you remember when we talked about Will setting up a testamentary trust when you pass away, my children have a testamentary trust, meaning if I pass away and my wife and I together pass away, a trust is set up based on the last will and testament that funds go into that trust for each of the children. Now, we do that because the children are still minors. They can't, number one, can't accept the responsibility of that money. Number two, probably can't open accounts to hold all of it. We need a trust to handle all that for them. So we're creating trusts for them, and that money will go into those trusts for their benefit while they're minors. And inside of that trust, you can dictate what happens to that money for them. You can do tiered age restrictions, meaning they can't touch any of it until they're X number of years, or the guardian can take money out for specific things, or it can be used for a certain percentage can be used for education. You can take money out for a car, for weddings, all that kind of thing. There can be event triggers. There can be age triggers. There can be percentage triggers. There can be flat dollar triggers. There's a bunch of different things inside of there that can be named, but be very, very, very careful of when you release the balance to the children. And the reason I say that is because, look, I love my kids, but they're completely different. I'm assuming your children are different. You want to be very careful about their responsibility level depending on their age. Now, if they're young, and you pass away, there's no way you would know what their responsibility level is going to be as an adult. You just do your best. But as they mature, as they age, you'll be able to see it. And then maybe at the time you pass away, they are now of age. They're no longer under 18. They're now over 18. And now your testamentary trust is very, very specific for what you want them to have at ages 30 or age 35 or age 40 or age 50. There can be income triggers. The income trigger for the child is if they're age 30 and they make X number of dollars, the trust will delve out a percentage of the trust or a flat dollar amount of the trust. So there's very creative ways to do this, but you need to be very, very intentional with what they are. They can be, again, for specific purchases. I mentioned education or a car or something like that, but it can go even further than that. It can be for housing and pet care and vacations and grandkids and anything and everything you can think of. All of these things can be dictated inside of a will or inside of your trust. So have some real conversations. If you're married, sit down with your spouse, talk about all these things. You can take a very complicated topic and make it very simple for your children and benefit them well. When you pass money from generation to generation, sometimes there's taxes involved, and you want to avoid those as much as possible. Shannon, can you clue us in on how heirs are going to be taxed when money's passed on?
I would be happy to. Now, this law will change from year to year. Whether you're viewing this video, whatever year you're viewing this video, and you're going to want to talk with your attorney and check current laws, and we'll be sure to update it, of course, as those change. Currently, the federal estate tax exemption is very, very high. Less than 1% of people will be subject to any kind of estate taxes on a federal level, just simply because you've passed away and transferred money to somebody else. Now, on a different level, you've got tax implications, for example, for IRAs or retirement accounts. Now, that's money that you've never paid any taxes on. So at some point, the IRS, who has a couple of programs to fund, they're going to want your beneficiaries to pay those taxes after you're gone. Recently, the law changed. Used to, you could take those distributions over the course of your lifetime if you're a beneficiary and spread the tax implications. In fact, you were required to take out a certain amount every year. Well, now the IRS doesn't really care when or how much, as long as the entire account has been depleted within 10 years. If you inherit a sizable IRA and you're already in a pretty high tax bracket, then that can do some damage. You're going to want to talk to your CPA to prepare for that. There's not a ton that we can do to get around that. One consideration is to consider converting some of your monies to Roth, or to transferring them to a non-retirement account as you approach death. And for any of you who have a crystal ball and can do that, that's one way that you can reduce the burden on that 10-year distribution period rule. But it's a matter of paying the piper now or letting your kids pay the piper tomorrow. It's sort of 6 of one, half dozen of the other, and it depends on what your needs and priorities and wishes are. In a non-retirement investment account, we really have a sweet deal right now under tax law. Assuming you're under that federal estate tax exemption amount, and you probably are, any non-retirement assets that you pass on will receive what's called a stepped up cost basis, meaning effectively no taxes are due. You hand your kids money, something that's a non-retirement asset, whether it's land or jewelry or mutual funds, whatever the value is on the date of your death, that will be the cost basis for the beneficiary. So if the beneficiary turns around and sells that asset the next day, then they don't have any gains tax appreciation that they're going to have to cover or settle up with in the IRS. It's a fantastic deal right now under US law, but again, that could change. Clarify with your CPA or tax accountant if you have questions about any of this, and you can reach out to us too for your specific situation and we can shed some light on it. One more topic to cover, and this is the question: DIY estate plan and a will, or hire somebody to do it for you? Elian, what do you suggest? Can you talk about the pros and cons?
Yeah, but I find a lot that you and I are backing up because there's so many nuggets inside of here. And the one thing I wish we'd have said earlier is this is 2021. As of the recording of this video is 2021, and we keep qualifying and saying as a current law, because laws change. There's things on the table right now for estates, for total estate assets and what you can and can't pass on. The cost basis issues are on the table. There's beneficiary laws are just changed. Minimum distribution laws are just changed. Please be very, very careful that when you're watching this video, that you're looking at current laws rather than the laws that we're talking about today. And that's why we're not really talking about specific numbers, because those numbers probably will change. So when you're speaking with your attorney or doing it yourself, make sure you understand what those numbers are for beneficiaries and what's going to be taxable and what's not. So the question is, can I do this myself? Probably. If you have an uncomplicated estate, This is, again, 2021, there's a lot of technology out there from a bunch of legal experts that will allow you to do this on your own. We're not affiliated with anybody, but we've had people that have had fantastic success with LegalZoom, US Legal Forms, Mama Bear Legal Forms. They're relatively inexpensive, and for on average between $100 or $120 per person, you can get a state-specific will, you can get a living will, you can get a power of attorney, you can get healthcare directives, you can get a medical POA, a financial POA. You can get all of those things together in one package for between $100 and $120, which is a steal. And it will be state-specific, which is incredibly important. But once you've done that, once it spits out all those documents, what Shannon talked about before is getting them signed. You sign them, having them witnessed, having them notarized. Even better, you're going to get digital versions of it. You can do revisions to them for the next 30 days without having to pay another legal fee. It's a pretty sweet deal. So if you have a relatively uncomplicated estate, this could be for you. But hey, Ellen, what if it's complicated? Well, let's look at what complicated is. First, a very large estate, which again, I'm not going to go in numbers, but I will say in multi millions of dollars to consider that to be a large estate. Assets in different countries, even assets in a different state. If you have property in Florida and property in Tennessee and property in Arkansas, those are 3 states with 3 very different real estate laws of how things are passed. You might want to get a very state-specific will for each one of those to decide what goes where. If you feel like you need to remove someone from your will, if you have a child that you're going to exclude or a family member you're going to specifically exclude, having a attorney help you with that, because there's very specific wording for that kind of thing. Also, you can't just drop their name off. That can be quite an issue. And then if you have concerns about someone that's going to contest your estate, if you have someone who you just know is going to make some trouble after you're gone, you want some very, very specific wording inside of your will. You really need to consider having an attorney help you. And if you need an attorney, we have quite a few that we refer out to that do a fantastic job. So if you would feel more comfortable using an attorney, those attorneys are not free. We've found that those services begin at between $800 and $1,000 and can range up to several $1,000s. But this is not something you want to skimp on. This is not something that we're trying to be frugal with, because there's way too many ins and outs in these things. We're big fans of paying an attorney to help you if there's any complication at all. So what does that take away? You can decide. You can decide how urgent a will is. Hey, Shannon, do people need a will?
I'd venture to say yes.
Yes, absolutely. Do people need a power of attorney?
Probably, especially if you're married.
Do you need a living will?
Yes, please
Okay.
help that person.
There are so many things that we're encouraging you to do today. There's some decisions you need to make, talking about guardianship for children, who's going to be your executor, who's your trustee. There are some decisions to make, and we talked about this in the previous video. Please don't let indecision paralyze you from taking that next step. This is so important, not for today, but for the future. To take care of everybody you want to take care of, to know where all of your assets are going, to make sure everything is properly in place. We find this incredibly important. So before we go, we want to make sure Elian Levatino, Shannon Acosta, the entire Benchmark team, we're here to help. Please feel free to reach out. Please call us. We can help you lay all these things out so that by the time you go see an attorney, all those decisions are made, and all that attorney has to do is write up that all those documents. We want to make this as easy for you as possible. Please lean on us. We really shine here. We're happy to help you any way we can.
And send us an email if you've taken action on any of those things. Did this spur you on to get a will? Let us know. Did it spur you on to get a power of attorney or a living will? Let us know. Did it just make you mad and frustrated and you don't know what to do or what the next step should be? Let us know. Either way, we want to be here to support and encourage you and cheer you on, because we're being very firm and adamant in our request, but it's hard. It's very, very difficult to do. So if you've taken that call already, we congratulate you. If you haven't, we encourage you and we support you, and you're not alone. So please drop us a line and tell us if this has inspired you to do any of that. It would make Elian's day.
Oh, it absolutely would. And it made my day that you're still watching this. If you went through both videos and you got all the way to the end, you are a champ. You are the bomb. So thank you for joining us for both of these videos all the way to the end. We look forward to talking to you soon.
Bye-bye.
Bye, everybody.